welcome you to the Duke University School of Law. My name is Walter Cox. I'm a senior judge of the United States Court of Appeals for the Armed Forces, where I had the privilege of serving for some 7 or 8 years of active service with Judge Robinson O. Everett, who was the chief judge of that court at the time. And following that service, he was kind enough to invite me to Duke University as a senior lecturing fellow, which is a sophisticated name in academia, I guess, for a guy who comes down and teaches a little bit. And I had the pleasure of teaching military law with Judge Everett and criminal law with Judge Everett. And I used this classroom to teach ethics to the law students 1 year. And I've stayed active teaching with Judge Everett and here at the law school over the last several years. A couple of years ago, I joined a law firm, Nelson, Mullins, Riley in Scarborough, that has its headquarters in Columbia, South Carolina, but has offices here in North Carolina and Raleigh and Charlotte and Winston-Salem. And I happen to be in the Charleston, South Carolina office now. But about a year and a half ago, I asked Judge Everett if he would allow our law firm to sponsor a seminar dealing with white-collar crime. And he said, well, you're not accusing me of being a white-collar criminal lawyer. And I said, no, sir. But I said, you're a legend of teaching criminal law, and we'd be honored if you would let us present one. And so I'd like to introduce Robinson O. Everett at this time. Judge Everett, why don't you stand up, and if you'd like to welcome your friends and colleagues to the seminar, you're certainly welcome.
Well, I certainly want to welcome all of you, and many of you are longtime friends of mine, and some of you even were victims of mine as students of the past. Whoever you are in whatever capacity, we're certainly very happy to have you here. I think Judge Cox has put together a wonderful program, especially with the aid of Paul Horn, who is outstanding in terms of instruction on federal criminal law. So we feel very privileged to have this second edition of the White Collar Crime Seminar.
Well, we're honored to put it on, Judge Everett. A couple of administrative types of announcements. I assume as you came through, you saw the restrooms and so forth. We're not going to take a long break during the afternoon, but we will take modest breaks as we exchange speakers, so we'll have an opportunity to use the restroom. And following the seminar, we're hosting a reception in the Birdman Lounge, which is on the 3rd floor, and I'll give more detailed directions on how to get down there. So we hope that all of you can join us for that following the seminar. I was telling Judge Everett, I never cease to be amazed and impressed at the stewardship that members of the bar are willing to give their time and their effort to share their experiences and their education and their specialties with the rest of us. And we've assembled, I think, a very excellent faculty this afternoon to talk about white-collar crime. And our first speaker is the Honorable Carl Horn III. I first met Judge Horn through a mutual friend several years ago, and learned that he is, in North Carolina, he is the dean of continuing legal education in criminal law business. He hosts a seminar in the second weekend, I guess, roughly, of December every year in Charlotte. It's very popular. He publishes a book, which is a case update book on crime and on the case law in the Fourth Circuit dealing with criminal law. He's published other books that I've had the pleasure of reading. An excellent one on a lawyer's life that I would commend to all of you, dealing with the art of just being a lawyer and enjoying life. Judge Horn is a graduate of the University of Virginia School of Law. He then came to South Carolina and is a graduate of the University of South Carolina School of Law. He is presently serving as the United States Magistrate Judge from Western District of North Carolina. And Judge Horn, you do us great honor being here. So I'm turning the program over to you. Thank you.
Thank you. Thank you all. Well, thank you all for being here, and thank you, Judge Everett and Judge Cox, for those very kind words. I don't usually tell lawyer jokes as a matter of principle, but I heard a pretty good one the other day that puts lawyers in a good light, so I think I might make an exception. Story goes that there was a hunting dog that was so good at finding birds that its old country owner named it Lawyer. But of course then proceeded to rent it out at a very high hourly rate. Lawyer was so good at finding birds that its owner was able, each time someone returned for another hunt, to double the price. So one day, a couple of guys came to take Lawyer out for the fourth hunt, and they were dismayed to hear the owner say, "Lawyer don't hunt no more." They said, "What do you mean he don't hunt anymore? We just took him out 2 months ago, and he was fantastic." The owner said, "Yeah, everything was fine, till some guy got confused and called him Judge. Now all he do is sit on his butt and bark." And I probably ought to not tell judges jokes either, as a matter of principle. But, we do get kind of beat up politically these days, particularly by those who want to call us all activists or whatever. But I heard most judges do the best they can, often under difficult circumstances, to achieve justice. I heard about a judge the other day in a lower state court who had a recidivist shoplifter before him, a woman, and asked the police officer what the facts were. The officer said, "Well, she stole a can of peaches this time, Judge." He's trying to know, "What do I do with her?" And he asked the police officer, "Well, how many peaches were in that can?" And the officer said, "There were 6. So, "Well, I sentence you to 6 days in jail, 1 day for each peach." At which point her sort of bedraggled-looking husband raised his hand and said, "Your Honor, she also stole a can of peas." Well, my contribution to your materials would be the first page inside the cover of what you probably picked up as you came in. And let me just take a minute to explain the format. What I have, for now 13 years, published an annual edition of the Fourth Circuit Criminal Handbook. It started with Mickey Press in Charlottesville, Virginia, and at some point they merged with LexisNexis, and they merged with Matthew Bender, and it is now published by them. And in between editions, we publish a reporter. It's called Mickey's Fourth Circuit Criminal Reporter, 8 times a year. And once a year we have this seminar that Judge Everett mentioned. And what I do is use the table of contents of the book, which is my best effort to provide an outline of federal criminal law as our order for the way we report the cases. Now, there is not a case dealing with most of these issues, but if you'll look at the table of contents, it's divided up. This is the contents for the book, and again, this is the order in which whatever has been reported in a published Supreme Court or Fourth Circuit decision, in this incident, in 1995 or to date in 1996, although we've had 3 published opinions this week, I have not had a chance to read and absorb, and a Supreme Court opinion, the one on search, consent to search, where one party says yes and the other party says no. The Supreme Court deciding 5-4 in a decision, I believe 2 days ago, that one party cannot consent to the search of space that another party is in control of inside the same residence. Like so many recent decisions, again decided 5-4. But so we start off with search and seizure, then we have a section on confessions and statements, pretrial issues. We won't be covering the next two, anything in the next 2 chapters, drug offenses or firearms offenses. Then we cover, in the order they appear for the most part in Title 18 of the United States Code, the substantive crimes in the order, again, the order they appear. Then we have various trial issues dealt with in the 7th chapter, sentencing issues in the 8th, and then appeal and post-conviction issues in the final chapter. I'm on page 10, and what I've done again is extract the cases that deal with white-collar crimes or that announce general enough principles that they might apply to white-collar cases. The first one of which is a vehicle search case, United States versus Bush, reported at the top of page 10 in your materials. In that case, the defendant drove a female to a bank who identified herself falsely as one of the bank's customers, then attempted to get a loan in that customer's name. A detective who had been alerted to this scheme followed the couple from the bank to the vehicle and arrested the female as she was about to get back into the vehicle. A search of the vehicle incident to arrest was then conducted. Applying the Belton decision, which permits the search of a vehicle incident to the arrest of an occupant of that vehicle, and the more recent Supreme Court decision in Thornton, which allows the search of a vehicle incident to the arrest of a recent occupant of a vehicle, the Fourth Circuit affirmed the district court's denial of the defendant's motion to suppress. Assertion of right to counsel. In Johnson, there the defendant was given a waiver of rights form which included the question, do you want to make a statement at this time without a lawyer? The defendant wrote no, and the detective left the interview room. About 40 minutes later, a second detective arrived, asked about whether the defendant had waived his rights, was told that the defendant didn't exactly request a lawyer, and so he went into the interview room and essentially talked the defendant into changing his no to a yes and into giving written statements, portions of which were incriminatory. Although the district judge described himself as troubled by the second detective's conduct and criticized his testimony at a suppression hearing as lacking in candor, he ultimately concluded that the defendant's initial no on the waiver of rights form did not amount to a request for counsel and denied the motion to suppress. The Fourth Circuit disagreed, concluding to the contrary that the defendant's initial no did amount to assertion of the right to counsel, after which all questioning by law enforcement must cease under Edwards versus Arizona, unless the accused himself initiates further communication. I think the most valuable aspect of Judge Mott's opinion in Johnson is the collection of cases from the Supreme Court, the Fourth Circuit, and other circuits in which certain statements or questions were found to be too ambiguous or equivocal to constitute the assertion of the right to counsel on the one hand, and then the corresponding list of cases where statements or questions were considered sufficient to be the invocation of the right to counsel. Those from the cases cited which did not constitute assertion of right to counsel included, I might want to talk to an attorney. Another case, do you think I need an attorney here? Another case, I might want to talk to a lawyer then, huh? Another case, I think I want a lawyer. Do you think I need a lawyer? And a final case, I can't afford a lawyer, but is there any way I can get one? Now, in contrast, the cases and the statements which different courts held did constitute invocation of the right to counsel included the Supreme Court decision, 1984, Smith versus Illinois, where Edwards was considered to be triggered, where the defendant responded to whether he understood that he had a right to counsel by saying, oh, yeah, I'd like to do that. A Sixth Circuit case, again, these are all cited with approval by the Fourth Circuit in this decision, finding the defendant had invoked his right to counsel by stating, maybe I should speak with an attorney by the name of William Evans, and then handing over William Evans' business card to the interrogator. A Ninth Circuit decision finding that the defendant's three questions constituted invocation of the right to counsel, those questions being, can I get an attorney right now, man? You can have an attorney right now? And, well, like right now, you got one? And finally, a Sixth Circuit decision where the defendant said, I'd just as soon have an attorney, because you know y'all say there's been a shooting involved, and that's a serious charge. And the question having been prior to that, would you answer some of our questions without an attorney present? Now, in this case, the court did find that what the defendant had said, no, I don't want to be questioned without an attorney, was the invocation of the right to counsel, but they proceeded to find, on the facts of this case, that it was harmless error beyond a reasonable doubt. Prior consistent statements, Hedgepeth on page 12. In that case, a member of the Richmond City Council was charged with accepting $2,500 in exchange for her support of mayoral and city council candidates. Although she acknowledged that she was wrong to discuss her support and payments in the same conversations, her defense was that the first $500 was a contribution to retire her campaign debt, and the balance, $2,000 in cash, was to support charitable work in which she was involved with children. On cross-examination, the government impeached the defendant's testimony with certain inculpatory statements she made orally to FBI agents following her arrest, but they would not allow the defendant to offer into evidence on redirect examination arguably exculpatory statements she had given in writing during the post-arrest interview. But the district judge did permit defense counsel to refer to these written statements and to elicit certain of the contents of those written statements, including the key fact that they did not admit the connection between the candidates and the money given. The Fourth Circuit found that exclusion of the written statement was within the district court's discretion, noting that, first of all, in regard to prior statements generally, the court that they are inadmissible, subject to certain exceptions. Second of all, under Federal Rule of Evidence 801D1B, the court noted that a prior consistent statement of a person who has testified and been subject to cross-examination is not hearsay and is admissible when the statement is offered to rebut an express or implied charge against him of recent fabrication, improper influence, or motive. The court cited the doctrine of completeness as a second exception to the general rule that prior consistent statements were inadmissible. But finally, as applied here, they rejected the defendant's argument that her written statement should have been admitted under the doctrine of completeness, first because it generally applies to a single statement, and here there was an oral statement followed a little bit later by a different and separate written statement. And secondly, they did not find the two statements sufficiently contradictory to allow a prior consistent statement to be admitted in this case. Right to counsel. U.S. versus Owens. The defendant there requested court-appointed counsel in his initial appearance. However, when he reported he had a net worth of $146,900 and monthly income of over $2,000, the magistrate judge just denied his request, finding he was not an indigent. About a month later, the defendant was scheduled for arraignment before the district judge. Still not represented, the district judge affirmed the magistrate judge's determination that the defendant was ineligible for court-appointed counsel, decided that he'd waited long enough, and proceeded to arraign the defendant. Over the next month or so, the magistrate judge conducted 2 status of counsel hearings. At the second of those, the defendant advised the judge that he had contacted one attorney who he couldn't hire because his fees were too high, and in fact, when he had filled out his initial financial statement, he had overstated his net worth, and it was really just a little over $50,000. At that point, the magistrate judge appointed an attorney to represent the defendant, subject to he was out on bond, paying a monthly amount to reimburse the government for those costs. The defendant argued on appeal that to proceed with arraignment while he was unrepresented by counsel was reversible error. But the Fourth Circuit disagreed with that, holding that by failing to retain counsel in the 29 days between the initial appearance and arraignment, the defendant had effectively waived his right to counsel at arraignment. And even if he had not waived his right to counsel, he was not reversibly or not prejudiced to the extent that it was reversible error. On this point of implied waiver of counsel, I've cited some cases in the final paragraph of that section where even requiring an unrepresented defendant to go to trial who has had a sufficient amount of time to retain counsel, unless they do qualify for court-appointed counsel, is not reversible error. Now, there is a decision more recently than these materials, just decided last week, but which are not in would be in this section, but are not in your materials. United States versus Alvarado, Alvarado. The facts in that case will be familiar to anyone who's involved in federal criminal practice today. It involved a drug case which was first charged in state court, but later dismissed once it was adopted for federal prosecution. But the legal issue presented was one of first impression for the Fourth Circuit. Now, it's long been settled that prosecution in state court and federal court for the identical offense is not double jeopardy. This is referred to as the dual sovereignty or the dual sovereigns doctrine. What was the unique holding here in the question of first impression was whether this same principle applies to Miranda and the right to counsel. In this case, there was a federal agent involved in the initial investigation, the initial arrest, and in fact, although there were only state charges brought, the initial assertion of right to counsel was to an ATF agent, a federal agent, but again, it was just a state prosecution. The court held that when that same agent went to pick the defendant up, who was represented in the state court by state counsel, to take them to their initial appearance in federal court, because the right to counsel is offense specific. Once this person, because they were in custody, were Mirandized again, the agent was free to commence questions to this represented individual. And by implication, if the defendant had not been in custody, he would not have even, it would not have been necessary even to advise him under this theory of his Miranda rights. This obviously has the capability of being much abused, which the court sort of noted in quick passing, but that was their decision in this case. Right to self-representation, page 15 of the materials. In that case, again, the Bush case, there was the kind of defendant that defense lawyers, prosecutors, and judges tend to agree on. They just drive you crazy. Now, he was already on his second appointed lawyer, and he asked for a third appointed lawyer about a week before the scheduled trial. Prior to that, he had agreed to plead guilty, but then when the plea agreement was tendered, he refused to sign it. Although he was represented, he filed a number of pro se motions. When his last-minute request for a third lawyer was denied, he asked to represent himself, saying, "I would rather be my own sacrificial pig and just go before the court on my own. I have that right and I want to exercise it." After the district judge, Andre Davis, gave the required caution about the hazards of self-representation, he asked the defendant, "Well, are you ready to go to trial?" Which the defendant answered by saying, "No, but you said you're not going to honor a continuance, so I have no choice." So they proceed with a formal colloquy before the judge decides whether or not to allow him to represent himself, during which the defendant revealed, among other things, that he had been diagnosed with manic depression, that he was on Prozac, that he had attempted suicide both as a juvenile and as an adult. And Judge Davis decided at that point he was not competent to represent himself and denied that motion. Then the defendant asked if he could absent himself from the courtroom by saying, "I would rather not be here to watch myself crash and burn." Judge Davis, taking note that the defendant was, quote, "smiling very broadly and grinning and fairly enjoying himself" during this proceeding, granted that motion, that is, to be allowed to be tried in absentia. The Fourth Circuit affirmed, finding no error on these facts either in the denial of the defendant's request to represent himself or in granting his motion to be tried in absentia. Page 16. These are significant changes. The Sell decision in 2003 having to do with the forced medication of an incompetent defendant for the purpose of trying to return them to competency pharmacologically by forcing them to take drugs or giving them injections. And the Supreme Court cut back and severely limited the showing, or limited the number of instances where the government could do that. They had to show that important government interests were at stake, that involuntary medication would significantly further those interests, that the administration of drugs is substantially likely to render the defendant competent to stand trial, and substantially unlikely to have side effects that would interfere significantly with the ability to assist counsel. Third, that that no alternative less intrusive was likely to achieve the same results. And fourth, that it was medically appropriate to forcibly medicate this defendant. Now, the Fourth Circuit came along last year and actually added to that initial burden and elaborated on and greatly expanded the showing of what it means to be a significant or an important government interest, of what they had to show in terms of what exact medications they were going to use, what were the side effects, what were they going to do if these side effects occurred, it basically has made it quite. This is usually done in practical fact near you all when we have our folks come over here to Butner, because the medical staff now gives us probably a 1/2 to 3/4 inch thick medical analysis that we base our decision about whether or not to allow. But to allow that, if we had to have experts come into court on a case-by-case basis, it would just be impossible to meet the sort of burden that the Supreme Court and Fourth Circuit decisions properly, I think, and wisely require. Page 17, venue of wire fraud and false claims. Ebersole. In that case, the defendant owned and operated a business called Detector Dogs Against Drugs and Explosives. He had secured about $708,000 in government contracts from various agencies to sell dogs for these purposes. The problem arose when government officials began to suspect that the dogs supplied by the defendant were either poorly trained or not trained at all. Eventually, the State Department, which was one of the contracting agencies, arranged to administer an odor proficiency or an odor recognition proficiency test to 6 of the dogs, randomly selected, which alas, all 6 dogs failed. The defendant was ultimately indicted on 25 counts of wire fraud and 2 counts of filing false claims. Although he prepared and presented the fraudulent invoices to various government agencies in other districts, the indictment was in the Eastern District of Virginia, where the invoices were sent for processing and/or payment, and where wire communications were transmitted. In rejecting the defendant's challenge to venue and affirming his convictions, the Fourth Circuit noted that both wire fraud and false claims are continuing offenses, meaning that venue is proper in more than one district. In regard to wire fraud, this means that venue is proper in any district where a payment-related wire communication was transmitted, whether or not it was sent by the defendant, once he set the process in motion. Similarly, in regard to false claims, venue is proper in any district where the claims are prepared, presented, or passed through. Assertion of privileges before the grand jury. In in-ray grand jury proceedings, the district judge denied a motion to quash a grand jury subpoena for documents and attorney testimony, which motion asserted attorney-client and attorney work product privileges. Although the district judge heard from the government in camera and satisfied himself it had made a prima facie case that the crime-fraud exception applied, he did not examine the documents themselves. In reversing and remanding for in-camera review of the documents, the Fourth Circuit first addressed the complexities and the nuances of when the crime-fraud exception vitiates, first, the attorney-client privilege, and secondly, the attorney work product privilege, distinguishing, as the case law does, between opinion work product and fact work product and the different standards used in deciding whether the crime fraud privilege vitiates those. The Fourth Circuit concluded that it was an abuse of discretion for the district judge to order the attorney to testify or the documents which might contain attorney opinion work product to be produced without first examining those documents or at least summaries of those documents in camera. A second grand jury case on page 20, in re grand jury subpoena. There, 3 employees of AOL Time Warner were interviewed by the company's general counsel and an attorney retained by the company to conduct an internal investigation. Each employee was told by the attorneys that they represented AOL Time Warner and that it would be up to the company to decide whether to waive the attorney-client privilege. However, the employees were also advised, this is another kind of common scenario, the employees were also advised by the attorneys that they could represent them too as long as there was no conflict of interest or no conflict developed. At some point later, each of the employees retained individual counsel. One of the employees, a Mr. Wakefield, manager of the Business Affairs Division, subsequently entered a joint defense agreement with the company. Several years later, a grand jury subpoena requested or required production of written memoranda and other written records reflecting interviews conducted by attorneys for AOL Time Warner of these 3, by then, former employees. The company waived its attorney-client privilege, but each of the former employees sought to quash the subpoenas. In affirming the district judge's denial of the motions to quash, the Fourth Circuit rejected the former employees' argument that they were entitled to assert attorney-client privilege because they believed, and I would say not unreasonably, that the attorneys were also at that point representing them, at least until a conflict of interest developed. The court essentially concluded that counsel's, as they described it, hypothetical pronouncement that they could represent the employees was insufficient to establish that they were representing them. Secondly, although the Fourth Circuit affirmed the general concept of a joint defense agreement, they said that this did not help Mr. Wakefield because his joint defense agreement was not entered into until months after these interviews were conducted. Page 21, motions to continue right to counsel. Hedgepeth, in that case, the defendant moved to continue sentencing on the day of the hearing based on a psychiatrist's report which had been received the day before. The defendant requested the continuance to investigate further whether she might be entitled to a downward departure based on diminished capacity. The Fourth Circuit found no abuse of discretion in the district court's refusal to continue sentencing, noting that the sentencing hearing had been scheduled for several months, that the psychiatrist's report had been received the day before sentencing but did not demonstrate further investigation would have revealed a basis for downward departure, and third, noted that the district judge had admitted and considered testimony from the psychiatrist and another doctor before sentence was imposed. Mail fraud. In U.S. v. Pierce, the defendant and his co-conspirators ran a bingo operation for a nonprofit organization in southwestern Virginia. At some point, they began reporting only a portion of the proceeds of the operation and pocketing the balance. Well, not surprisingly, when they sent their regular reports, which were mailed, they omitted the receipts they had stolen. In order to prove mail fraud in violation of Title 18 U.S. Code Section 1341, the government must prove that the defendant knowingly participated in a scheme to defraud, and secondly, that he or she mailed or caused to be mailed something for the purpose of executing that scheme. In this case, the defendant essentially argued that the second element had not been proven, that the mailings after the money had already been taken were not for the purpose of executing the scheme. A divided panel disagreed with the defendant, likening the post-theft mailings to lulling letters and affirming the mail fraud conviction. Judge Gregory, however, in a strenuous, vigorous dissent, was not convinced by the government's argument, arguing that this case demonstrates the dangers inherent in extending federal jurisdiction beyond that which Congress intended. He would have left this prosecution to the state courts. Money laundering, I'm on page 23. In Whitfield versus the United States, a Supreme Court decision, the court resolved a split in the circuits over whether convictions for money laundering conspiracies require proof of an overt act. In an opinion written by Justice O'Connor, a unanimous court held that it did not. This was also the holding shortly thereafter in the Fourth Circuit decision in Alerre, A-L-E-R-R-E, reported at the end of that paragraph. The Fourth Circuit made two other noteworthy points in the Alerre decision. First, that to sustain a conviction for conspiracy to commit money laundering, it is not necessary to prove that the substantive crime itself was committed, only that there was an agreement to commit it. And secondly, the court noted in dicta that in a case charging promotion money laundering, the promotion element was satisfied when a defendant simply paid a subordinate employee for participation in the unlawful scheme. Page 24, hearsay, forfeiture by wrongdoing. In that case, U.S. v. Gray, the defendant was charged with mail and wire fraud involving murders of her husband and paramour and subsequent efforts to collect their life insurance. The defendant unsuccessfully objected to the admission of incriminating statements that her husband had made about her and her accomplice, who was her paramour, who didn't know he was going to get it too, several months before his death. He wasn't feeling well, and he had some suspicion that it was the food that his dear wife was preparing. Citing the forfeiture by wrongdoing exception to the hearsay rule, adopted in 1997 as Federal Rule of Evidence 804b6, the Fourth Circuit found no abuse of discretion in admitting the victim's out-of-court statements. The court noted that a defendant who wrongfully and intentionally renders a declarant unavailable as a witness in any proceeding forfeits the right to exclude on hearsay grounds the declarant's statements. Page 25, prosecutorial misconduct. In U.S. v. Collins, the prosecutor made the following statements during her rebuttal closing argument. That plea agreement is a contract between them, speaking of the cooperators, and the United States, which means that they have certain functions and we have certain functions. Their function is to tell the truth. Each witness who got up there said that his job or responsibility was to tell the truth. The government is always seeking to determine whether they are telling the truth, and we do not take lightly the fact that we have an agreement with the defendant with each one of those witnesses where they're supposed to tell the truth. Although the Fourth Circuit concluded that the prosecutor's statements either crossed the line into impermissible vouching or at best was a close call, they ultimately found no reversible error on these facts. Applying the four-part test for reversible error, the court concluded first that it was unlikely, considering the overall context in which the statements were made, that the prosecutor's statement actually misled the jury. Second, the arguably improper remark was isolated. Third, the third factor, which is the strength of guilt absent the inappropriate comments, weighed in the defendant's favor, noting that the government's case relied heavily on the testimony of these cooperating co-defendants. But fourth, again in the government's favor, that the remarks were not deliberately made to divert the jury's attention. Rule 29 motions. Rule 29B of the Federal Rules of Criminal Procedure provides in part, the court may reserve ruling on the motion, proceed with the trial where the motion is made before the close of all the evidence, submit the case to the jury, and decide the motion either before the jury returns a verdict or after it returns a verdict of guilty or is discharged without having returned a verdict. If the court reserves decision, it must decide the motion on the basis of the evidence at the time the ruling was reserved. In U.S. v. Gray, the defendant moved for judgment of acquittal, Rule 29, under Rule 29, at the close of the government's evidence, arguing that the government had failed to prove a mailing in support of a mail fraud charge. Although the government contended that there was sufficient evidence from which the jury could conclude that there had been a mailing of pleadings to the courthouse in this case, and the district judge nevertheless allowed the government to reopen its case in chief and called the defendant's former lawyer, who testified that he had in fact mailed those pleadings. The defendant argued on appeal that Rule 29b was violated in that the district judge based her ruling in part on evidence received after the motion was made. The Fourth Circuit disagreed, noting that the final sentence of the rule was intended to address the problem that arises when the defense decides to put on evidence and runs the risk that defense evidence would support the government's case and defeat Rule 29. The court noted that that was not true in this case because it was the government which was allowed to reopen its case in chief. And under Rule 29b, the district court was permitted to consider all of the evidence presented in the government's case in chief, both before and after it was reopened. Sentencing guidelines. I'm not going to say much about that because we have a speaker who is the acting general counsel of the U.S. Sentencing Commission and a true expert on the sentencing guidelines. And I just dabble in it. But this basically, what she'll talk about is more of a global scope. And I'll just tell you that what you have in your materials here is my best shot at discussing the Booker decision, which was really two Supreme Court decisions, Booker and Fan, which addressed the constitutionality of the U.S. sentencing guidelines, the question being whether the Supreme Court's earlier decision in Blakely was applicable to the sentencing guidelines. You'll recall that the Supreme Court in two opinions issued that came out of that combined case, first of all held that the mandatory guidelines did violate the Sixth Amendment, and second of all, however, that it was all right to require the district courts to consider the proper guidelines range if they weren't mandatory, if they were merely advisory. And second of all, the standard of appeal had to be adjusted to simply a review for reasonableness. And I think Pam, our expert, will talk some about that. As we talked about at lunch today, the Fourth Circuit has surprised me quite a bit. And again, all the decisions until the few that I haven't had a chance to read that were published this week in 1995 and 2005 and 2006 are noted here and cited. Many reversals based on Booker error. But as far as the sentencing process, I don't know if you all practice in the Eastern District or the Middle District, but in our district, our district judges are quite frustrated by the much, ironically, although I think the Supreme Court probably, I don't think there are any former trial judges on the Supreme Court at the moment, but they probably thought they were making the process simpler and more flexible. Our experience at the district court level is quite to the contrary. It takes a whole lot longer to get it right post-Booker than it did before. And also our experience is that the Fourth Circuit is quite quick to reverse as unreasonable sentences. It would seem to me that they're more likely to reverse sentences in this supposedly more relaxed standard of review on appeal than they were before. Again, if you want to read this in greater detail, I won't belabor it, but what I've tried to do here is go through all the cases and then suggest what is the sentencing scheme post-Booker at the district court level, and that would be in your materials on pages 30 and 31. I also have cited some cases in the bottom of 32 and the top of page 33 where the Fourth Circuit, in a minority of the cases post-Booker, have not found Booker error to be reversible. Page 33, amount of loss. In U.S. versus Pierce, this was the bingo case. 4 defendants were charged with mail fraud. 2 defendants entered plea agreements with stipulations concerning the amount of loss, and 2 went to trial. Of the 2 who went to trial, 1 was acquitted and the other was convicted. This appeal involved the individual who went to trial and was convicted, challenging the amount of loss found for purposes of his sentencing. His argument was essentially that he should receive the benefit of the government's stipulation as to amount of loss in the plea agreements with his co-defendants who pled guilty. Doesn't sound terribly unreasonable, but unfortunately it's not consistent with the law. The Fourth Circuit disagreed, rejecting the defendant's collateral estoppel and equal protection arguments. The defendant who goes to trial, in a sense, I guess, as far as amount of loss and a lot of other sentencing factors, is rolling the dice, and the Fourth Circuit had no interest in changing that phenomenon or principle. Role in the offense. U.S. Sentencing Guidelines Section 3B1.1a provides for a 4-level enhancement if the defendant was an organizer or leader of a criminal activity that involved 5 or more participants or was otherwise extensive. Although the crimes charged in U.S. versus Rubion involved only 2 people, that it would be the defendant and his girlfriend, whom he persuaded to commit perjury in his behalf, the district court concluded that the criminal activity was, quote, otherwise extensive in that it included the unknowing services of the defendant's lawyer, his staff, and most importantly, the 12 jurors who acquitted him based on the perjured testimony. The Fourth Circuit disagreed, distinguishing United States versus Ellis, in which it had approved a role in the offense adjustment enhancement based on otherwise extensive criminal activity, where the scheme was to secure passage of legislation and involve lobbyists and other legislators. They said here, in contrast, in this case, the jurors in the first trial did nothing to advance the defendant's scheme. His scheme was simply to obstruct justice by lying to the court and having his girlfriend do the same. So the enhanced sentence was reversed and remanded for resentencing. Abuse of position of trust. In U.S. versus Ebersol, the Fourth Circuit reversed an abuse of trust enhancement due to insufficient evidence of a fiduciary relationship between the defendant. This is the gentleman who supplied the untrained or poorly trained drug and explosive detection dogs and the agencies that he defrauded. The court agreed that an enhancement for conscious or reckless risk of death or serious bodily injury was appropriate, but found an insufficient factual basis for the abuse of position of trust enhancement. They cited a case out of our district, Kaplinger, where the defendant in that case representatives from the Dominican Republic represented himself to be a medical doctor who had found the cure for AIDS and solicited Western money as an investment in his enterprise. And not the people he came to, he didn't have any patients. It was all an investment fraud thing. And the court reversed the abuse of a position of trust because this doctor, this fellow representing himself to be a doctor, did not have a position of trust with his potential investors. Criminal history, U.S. versus Collins. In that case, the criminal history of this defendant was Category 3 due to DWI convictions in 1988, 1999, and 1990. At the sentencing, the defense lawyer persuaded the district judge not to consider the DWI convictions because there was no information concerning whether the defendant had been represented by counsel in those proceedings or had received any active jail sentence. The defendant stated at sentencing that he just didn't recall whether he'd had an attorney on these 3 occasions, which the district judge found persuasive, imposing a sentence based on criminal history Category 1. The Fourth Circuit, however, found this, quote, difficult not to view with skepticism. In any event, the Fourth Circuit found that the district judge's failure to apply the presumption of regularity to these state convictions, effectively shifting the burden to the government to prove that the defendant had been represented, that everything was done in accordance with due process, was improper as a matter of law, reversing and remanding for resentencing based on criminal history category 3. Just two more cases to note, one regarding restitution, the other regarding a fine. Johnson is the case which had a restitution issue. It's interesting. They're the victim of a violent crime, and again, this is a case, it's not a white-collar case, but could very well apply in the white-collar context. U.S. v. Johnson, the victim of a violent crime, received psychological counseling from Child and Family Services, but at a much reduced rate. The narrow question on appeal was, two of them, first of all, whether the government's failure to notify the defendant within 10 days of sentencing that it would not be prepared yet to give a full amount of proper restitution figure at sentencing should prevent the government from later coming up with that figure. And second of all, and more interestingly, whether the court erred in awarding this Child and Family Services organization, which provided these services at a much reduced rate, as a charitably motivated thing to help their patients and clients, could receive restitution in the amount of the full value of those services, not the reduced rate. The Fourth Circuit answered both of those questions. Yes, that what the court did was proper. When the restitution couldn't be determined until later, it was all right for the court, once that information was there, to reconvene and supplement the judgment with the restitution amount. And second of all, that the organization that provided the services could be awarded restitution in the full amount of what they would have been, what they would have charged in an arm's length transaction. And the final case is not new law, but just again a fairly small fine, in this case $2,000, but without the required specific findings of the defendant's ability to pay that fine. The judge simply said, going to be incarcerated for X number of months, and they can pay a couple $1,000s a little bit at a time over that period with no further findings. Although there's not in the law such a thing, over the years there's been a de facto minimum fine exception that has developed, and I cite some cases on page 36 similarly holding fines up to, in this particular line of cases, $6,000 as not being reversible because no findings of ability to pay. There we have it. Those are, as best I can tell, most or all of the published Supreme Court and Fourth Circuit decisions in 2005 and up until this week in 2006 in the Fourth Circuit and in the Supreme Court. I started a little bit late, but I guess my time's up. We want to get back on schedule.
Well, if anyone has any
If
questions,
I have maybe a quick question or two or a comment. Yes, sir.
I'm just interested in this case, U.S. versus Gray, on this evidentiary ruling. And I wonder how the court can rule on the evidentiary ruling that seems to me to go to the ultimate issue in the case. And that is that, the court is basically saying this person killed this person, and therefore they're not available to testify in the trial of them for killing that person.
That's a good point. That's a very good point. It does presume that she made him unable to be present to testify, and I can't really address that. That's an excellent question.
And the court didn't comment on that at all?
No, just I guess they presumed that was an allegation, and that maybe the allegation itself was sufficient in the way that to deal with that is with contrary evidence or cross-examination. Yeah, I don't think they did not address that. Just presumed it.
In essence, the court's ruling on the ultimate issue there, on the evidentiary.
It sure comes close to that, doesn't it? You're right. Question: anybody in this room involved in any of those cases as counsel? No. I frequently, when I have prosecutors in the room, I've prosecuted that case, or I argued that case on appeal. So, and then you have to really get it right. Well, thank you all. Probably have to surrender the
Thank you very
microphone.
much. And I'm gonna get you to
There was a problem.
Is everything okay? Ladies and gentlemen, as I mentioned, I didn't build in any long break, so if you need to rest a moment. Before I get to introduce the next speaker, I'd like to, Judge Horn probably doesn't even know this, but on page 11, when the court cites Davis versus the United States, the history of that case is very unusual. Davis was a sailor stationed in Charleston, and he was questioned by the NIS, which is the Naval Intelligence Service, and he gave an equivocal answer when I asked, do you want a lawyer? Something like, well, do you really think I need one, or something like that. And the trial judge, was a military judge, decided that that was not an invocation of his rights. It came to appeal at my court, the United States Court of Appeals for the Armed Forces. And we decided that there was in fact, there were three different views then prevailing in the country. One was that you had to make an absolute invocation of the right. Do you want a lawyer? Yes, I do. Or you had to say, no, I don't. If you were equivocal, then that was not an invocation of the right. Some courts had held, well, equivocal, then it was an invocation of the right. And the third court said, if it was equivocal, the police investigator had a duty to clear it up. Well, they went to the Supreme Court from the Court of Appeals for the Armed Forces and not from one of the United States District Courts. It became the leading case on you had to make an unequivocal demand for a lawyer became the rule. So that's very interesting.
What was your court's holding?
That was our court's holding. No, maybe we held, I forget. Maybe we held, the policeman had to clear it up. I can't remember. But speaking of that court, our next speaker, Pam Barron, I first met her when she was an Army judge advocate who was representing the United States, or the government, on appeals before the Court of Military Appeals, I guess in those days, wasn't it, Pam? Pam is a graduate of the University of Virginia, undergraduate school, and then went to William and Mary and got her law degree. And she fell in love and married a young military officer who was posted in Fort Stewart, Georgia. And it looked like he was going to make a career out of the Army, so she